The most common contractual mistakes. Episode 1, Not having a valid and enforceable contract. Part of the series, Global Business Law in 20 Minutes with Federico Vasoli.
Welcome to the Lawyers and Mediators International Show and Podcast by InstantMediations.com, where we discuss law and conflict resolution topics to educate both professionals and everyday people. Catch regular episodes on YouTube, the Instant Mediations app, and anywhere you get your podcasts. Just remember, nothing in these episodes constitutes legal advice, so be sure to talk to a lawyer, as cases are fact-dependent.
Hello and welcome to today's podcasts. I am Natalia Ołowska-Czajka, advocate, mediator, and arbitrator from Warsaw, Poland.
And hi, I'm Mac Pierre-Louis, attorney, mediator, arbitrator working throughout Texas and Florida.
And hi, I'm Federico Vasoli, Italian lawyer with offices in Malta, Singapore, and Vietnam. It's great to be here.
All right. Thanks so much, everyone, for joining us again. So this is a special day. We are starting a new series with Federico Vasoli, and it's going to be episode 1 of this sub-series. Now, Federico is going to be speaking about global business law in general, particularly involving the work that he's done from Europe all the way to ASEAN. But while he will be talking globally, he's also going to be diving in to these sub-series. The first of which is going to be on contractual disputes. And so episode 1 of this new sub-series is going to be not having a valid and enforceable contract. So welcome, Federico. Please tell us a little bit more about yourself, since this is episode 1.
Thank you very much, Mac. It's great to be here at Instant Mediations. I'm very grateful that you invited me, and it's great to kick off this series with contracts, which is the most typical legal thing we have in place when we do business, not just internationally, but also at a domestic level, at a local level. I am the managing partner of DMTV Global, which is a firm that provides legal and tax advisory based in Singapore, Malta, and Vietnam. And yes, contracts is probably the most typical legal tool that we use on a daily basis with companies and individuals alike.
Having said that, Federico, can you please explain to us and to our viewers and listeners, why do you think many businesses do not have valid and enforceable agreements in place, even though they are in business with other business partners?
It's a very good question. I believe that it is perhaps a cultural reason. I don't think it is a matter of education. It is a matter of perhaps resistance towards the legal world, towards legal jargon, legalese, complicated stuff. It is perhaps a sign of disaffection and mistrust towards the judicial system, because perhaps everyday people are not familiar with alternative dispute resolution methods such as mediation. And they feel that even if they're right and even if they have a contract in place, eventually they will not find justice in an ordinary court of justice. It will take forever, it will be expensive, and for the sake of saving time and money, they could do without a valid contract in the first place. And that is the first mistake that many businesses make when doing business, especially internationally, when laws are sometimes very different one from the other. And eventually what happens when something goes wrong? You are without tools, you're without weapons. So that is a big, big mistake. You should always have a contract in place. And hopefully this contract is valid and enforceable.
And whenever I think about your response to that question, I imagine that it's true. Human nature doesn't change no matter where you go around the world, right? It's always the same problem. In the jurisdictions where I practice, you see the same kind of thing. Parties choose not to do a contract, and possibly for the same reason you just said, which is that they don't trust the system, the judicial system. So, but let's say this, even if a business does recognize the importance of having a proper contractual agreement, sometimes they may think that it's still a waste of time and money and not worth the benefit. Can you comment about this?
It's simply not true. It depends, of course. Typical lawyer's answer, it depends. But reality is, it is not true. It is worth spending time and money to go through a proper agreement, because eventually, and it is most common, it is more common than not, if there is a disagreement, even just an interpretation, I'm not saying that you go to court, that you fight with the other party. No, simply if you need to check what the agreement is. What did we agree on? I forgot. What time should we deliver this thing? How much money should we pay, etc.? You have to have a point of reference. So the point of reference is the contract. And in civil law, but also in common law, we say that the contract is the law between the parties. Set the rules, your rules. You can set them yourself as long as they comply with imperative norms and they don't go against the fundamental principles of the legal system and, of course, of other laws. But as long as you have something that is custom made for you, you are the master of your contract. You can draft whatever you want that is legal. And this way you can retain full control. And it is actually good to negotiate with the other party the content of that, because there is no disagreement, no misinterpretation, no misunderstanding in the future, hopefully, because he will discuss it in advance. He will say, okay, we'll pay this, we'll deliver at this date, these are the conditions, this is what we determine to be a case of non-performance, this is how we define force majeure, and so on and so forth. So it is definitely worth it. And there are so many examples that I could make. I mean, recently I had a case of a company in the Far East that needed to recover some money from a client of theirs. They needed to pay them close to $100,000, and they didn't have a contract in place. So in this case, we would have had to collect evidence to show that we actually had the right to collect this money on behalf of our client against the other client, against their client. So it was a long and expensive effort. Eventually, they will probably spend more in collecting pieces of evidence, in going to court, well, perhaps before going to court, in sending legal letters, in sending warnings, in spending time, in wasting time, really, rather than having a proper contract in place to say, hey, you violated this term, you need to pay me by now, that's it. It's much faster if you think about it. You do business quicker without having a contract start immediately, without drafting anything, without wasting time, in inverted commas, to draft it, to negotiate it. But then when problems arise, and they do arise, unfortunately, it's business, then you waste so much time and money in order to fix things. And sometimes they cannot even be fixed because it is too late. It happened to us. This is another case. In Vietnam, we had to, we had to collect money for a client that did not receive the goods that they ordered from Italy, all the way from Italy. So when you say that people are the same all over the world, it is true. There are a lot of, we're all the same in the end, whether in America, in Europe, or in Asia. But eventually there was a contractual non-performance, and trying to recover the money and the goods for our clients, it actually happened on at least 2 instances that I can recall recently in the past 2 months, was virtually impossible. They wasted time, they paid for goods that they never received. And had they had a valid contract, an enforceable contract in Vietnam, they would have gone immediately to court, even to the police, because in this case, it would have been perhaps a criminal case. So they would have had it enforced immediately. And that, unfortunately, was not the case. They lost money, they lost their goods, they lost their business, and they had pretty bad headaches.
And I use the arguments to my clients to persuade them that they truly need a contract, and a valid one and an enforceable one, explaining them that we do not write contracts for the times where everything is going smoothly. We write the contracts especially for the times when things go bad. And then when people are in disagreement, there is at least, as you said, a point of reference. But can you tell us some more? What do you think about that? Because sometimes businesses do think they have an agreement in place, but then it turns out that it is not valid or it is not enforceable. How would you advise your clients or our listeners and viewers to make sure in advance that an agreement is valid and enforceable?
Yes. First, let me comment on what you said. It is, I totally agree with what you said, Natalia. It is also, it is a point of reference. The agreement is, the contract is a point of reference. So you don't necessarily need to have a disagreement. As we said before, we simply want to check that we are complying with what we decided to, with what the rules that we decided are. And it's also good to negotiate the contract in advance in order to clear the path from possible disputes in the future. So that's quite an important point that you made, and I'm reinforcing. Your question was whether a company knows if it has a valid contract. Sometimes they don't even know that they have a valid contract in place. For instance, when they sign or they tick on accept the terms and conditions when they purchase stuff online, it is debatable whether terms and conditions that are one-sided, that are drafted by one party, are effectively enforceable. Most of the times they are. Of course, this does not constitute legal advice, so it really depends on your personal case. But sometimes you do have a binding agreement or a binding piece of documentation that you don't know you have, first of all. For example, exchanging messages. Now it is very common to conduct business with instant messaging tools, such as WhatsApp and others. Well, courts have started for a long time now to accept certain messages as pieces of evidence, long past the days when courts said, no, an email is not a valid piece of evidence. Now, not just emails, but also Facebook messages, WhatsApp messages, and so on. So be careful with what you exchange. If you write something quickly on your smartphone saying, yes, I agree, yes, let's do that, let's pay this sum of money, let's sell this kind of good with these specifications, be careful, because you may find yourself bound to a legal agreement. And in order for companies to make sure that they have something in place, again, you need somebody that is familiar with the legal jargon and with the legal tools. So in other words, at times, what we call contract, what we call differently from a contract is in fact a contract. Think about MOUs. A lot of people prefer the term letter of intent, memorandum of understanding, softer in a way definitions. But in reality, they are contracts. A letter of intent is not really defined legally by most legal systems. In the Italian legal system, we don't have it. It's not really defined. We have quasi-contracts that are developed by scholars. But reality is that either it is a contract or it is not, regardless of what you call it. To make things simpler, it's like calling apples oranges and the other way around. If you go to the grocery store and you buy oranges, and you can still call them apples, but they're oranges. And that happens more often rather than not. Again, I had clients in the past, especially from Italy, that said, we don't really want a contract with our clients. We want, a letter of intent. I said, okay, what do you want to write? Usually a letter of intent is an instrument that you use to prepare for a future contract. It is widely used in Asia, especially in order to determine the steps of negotiations for very complicated transactions. You write a letter of intent to say, okay, we agreed on the price. Let's fix it in a letter of intent, and then let's move on to, quantities or other specifications, etc. But that's a tool. It serves a certain purpose. When clients ask me for a letter of intent, in reality, they want a contract. They have a contract. They want a contract. And if they write letter of intent, they are indeed bound by that. And it happened so many times to see clients that they didn't know that they had a contract in place. Also, you have various pieces of documentation here and there. You may have a simple agreement that says we're charging you X, or you have to meet the specifications, etc. But then all the details, all the fine print is contained in small print, in the small prints in the purchase orders, in terms and conditions, and so on. So what many everyday people do not really know is that the contract is not that stack of papers that are signed, or that document, that PDF document that you have in your server. It is the combination of all these things. And that's why we have specific clauses that say, for instance, that this agreement represents the entire agreement between the parties, nothing else. So forget about the messages, forget about the terms and conditions, etc. But if you don't have a clause like that, it is likely that if you have terms and conditions here, an agreement here, a letter of intent there, etc., all these things together combined form the actual agreement, the actual contract between the parties. And again, it is a big headache because there may likely be conflicting information and differences in interpretation of each document.
Yeah, thank you. Very informative, because whenever you are dealing with multiple countries, multiple languages, and now multiple documents, I mean, the layers upon layers of confusion can really screw somebody over, okay, for lack of a better word. But speaking of languages, by the way, how many languages do you speak?
Well, Italian is my mother tongue. English, French, Spanish, My German is very rusty, unfortunately, and I utter a few words of Mandarin Chinese and a few words of Vietnamese and Maltese, but I cannot even pretend to speak. I wouldn't write in a CV that I speak Vietnamese or Maltese. Anyway,
Well,
so but
that's
English and
impressive.
Italian, English and Italian. Let's put it away. But
Yeah.
actually, sorry to interrupt you, Mac, but this is quite interesting. The same in Latin, the root for betrayal and for translation is the same. So translating is always betraying the original meaning of the text. So
Interesting.
yeah,
Yeah. No,
one has
I
to be
asked.
careful with translations.
I asked because you're dealing in the world of communication and agreements across different cultures, across different judicial systems. So I think that people should appreciate that you have a pretty complicated job sometimes, right?
Yes.
Because especially trying to get people to see eye to eye, and this is why I brought up the word communication, right? Because you're trying to make sure people mean what they say in the same context on the same piece of paper across thousands of miles, and that's pretty important.
And even
So,
more importantly,
mhm,
sorry to interrupt you, is
mhm,
if you have a mediator, if you have a judge that reads that contract, or
yes,
perhaps those various documents that constitute the agreement altogether, that person has never heard of you and your case. And you have to be able to write something that is simple and that the mediator, the arbitrator, the judge will be able to understand years after the events took
mhm,
place. So that's also why it is important to have somebody that understands legal jargon and all these fine details, because it is prepared for the future, and we don't know when and if future circumstances will occur.
correct, correct. So, outside of the legal world, there is a lot of confusion about what an agreement is and how it is drafted. So, what's your optimal and practical suggestion in this sense?
I would suggest having one single document that is properly drafted by somebody that knows how to draft contracts, that is qualified in certain jurisdictions, that understands the subject matter. That's why you have lawyers that are specialized in different fields: telecommunications, energy, cosmetics, you name it. There are so many fields. And the practices, the customs in each industrial field are different. So essentially, I would keep things very simple, making sure that the agreement is valid and enforceable. I've seen cases of perfectly drafted agreements that eventually were not enforceable because, for instance, in China or in Vietnam, you need to have a contract that is also not just signed but also stamped, and that is a lack of an essential formality. To the extent that even if you draft the perfect contract, it happened to a company that we assist in the logistics industry that had many years ago. They had a perfectly drafted agreement by a very good Swiss lawyer, except that the formalities were not perfect, and therefore they could not have the agreement enforced in Vietnam. Too bad.
Thank you so much. And I thank you for bringing this up, because the formalities, meaning the legal requirements for the validity of the contract, is usually a thing that you need to dedicate to lawyers. And it is not something that you can just Google in the internet or
Absolutely.
and it does require a lot of knowledge and expertise to address those issues correctly, notwithstanding the fact that the lawyer who is helping you, who is drafting the contract, is taking the responsibility for it. And then the possibility of really getting them liable for the mistakes, the professional mistakes they are making, is absolutely there in place. And please remember that in many jurisdictions, it is a professional obligation of the lawyers to have the insurance coverage, which then makes it far easier in case of anything being not done the proper way to recover the things, sometimes even easier from your than from your opponent, from the person that you were actually a party into the contract with, which is again not a part of the legal advice. But look how fascinating it can all be, how many things you can say whether you are having or not having a valid contract. Those little points in the contract, which Federico emphasized, should be really simple and really short, but there are many. And you should just sleep nicely and peacefully, knowing that you have a lawyer who will take care of that, draft it correctly, so that if any difficulties come, it can be easily used, easily deciphered, easily put in place for the legal solutions. Having said that, I would like to close and invite you to the next episode of our series with Federico Vasoli. Thank you, Mark. Thank you, Federico, and see you in the next episode.
See you.